Every concert ticket you've bought in the last 5 years included a hidden charge. A federal jury just put a number on it, $1.72 per ticket. Not for taxes, not for the venue, not for the artist. For the existence of an illegal monopoly between Live Nation and Ticketmaster, the verdict reached unanimously on April 15, 2026. Across hundreds of millions of tickets sold from 2020 through 2024, the total bill, by Live Nation's own filings, is approximately $450 million. With statutory automatic trebling, the exposure runs into the low billions. The trial took 5 weeks. The verdict form ran 11 pages. The jury found, on every claim, that Live Nation and its wholly owned subsidiary Ticketmaster operated an illegal monopoly that harmed competition in every one of 34 states that brought the case. The case is not over. The remedies phase will run into 2027 and likely 2028, and Live Nation has vowed to appeal. But the jury has answered the underlying question that every concert-goer has asked while staring at their ticket fees for the past 15 years. The fees are not market prices. The fees are the price of a monopoly, and the court has now found the dollar amount. Live Nation and Ticketmaster were two separate companies until January 2010, when the United States Department of Justice approved their merger after a year-long antitrust review. The combined entity unified 3 functions that had previously been performed by separate businesses: concert promotion, primary ticketing, and venue ownership. The promoter is the company that books artists, organizes tours, handles logistics, and takes a cut of ticket sales. The primary ticketing service is the company that actually sells tickets to consumers, handling the website, the payment processing, and the fees. The venue is the physical building where concerts happen. In a competitive market, those 3 functions would be performed by separate companies that negotiate with each other. The promoter selects the best ticketing platform for each show. The venue chooses which ticketing provider to use. The promoter and venue negotiate over who gets which share of revenue. After the 2010 merger, Live Nation could perform all 3 functions internally for any tour it promoted. The promoter could choose its own ticketing platform. The promoter could route its tours to its own owned and operated amphitheaters. The venue could exclusively use the merged company's ticketing service. The state's lawsuit alleged that the merger created the structural conditions for the company to exploit market power across all 3 layers simultaneously, and that the company used that exploitation specifically to raise consumer ticket fees above competitive levels. The DOJ's 2010 approval included a consent decree intended to prevent such exploitation. The 2024 lawsuit alleged that Live Nation systematically violated that consent decree for over a decade. The mechanism by which the monopoly produced consumer overcharges runs through a specific line item on every concert ticket: the service fee. When you buy a ticket on Ticketmaster, the face value of the ticket, the amount the artist and venue have agreed should be charged for the seat, is supplemented by a service fee, a facility fee, a processing fee, and sometimes additional surcharges. These fees are set by Ticketmaster, not by the artist. They are typically a percentage of the face value, ranging from approximately 20% of the face value for low-priced tickets to as high as 30 to 40% for high-priced tickets. On a $100 face value ticket, the consumer typically pays $120 to $140 before the transaction completes. Approximately 75% of the fee revenue is retained by Ticketmaster. The remaining share is distributed to the venue, the promoter, and in some cases the artist as a fee rebate. The structural problem the antitrust lawsuit identified is that competing ticketing services would charge lower fees if venues and promoters could choose them freely. The lawsuit alleged that Live Nation systematically prevented this choice through 3 mechanisms: requiring its owned and operated venues to use Ticketmaster exclusively, conditioning concert promotion services on venues' agreement to use Ticketmaster, and threatening to route artists away from venues that used competing ticketing platforms. The jury's $1.72 per ticket overcharge finding is the dollar equivalent of those mechanisms, the average amount by which fees would have been lower in a competitive market. Per ticket, it is small. Aggregated across the hundreds of millions of major venue tickets sold per year, it is approximately $300 to $450 million annually in consumer overcharges. A central dispute in the trial was how to define the relevant market. The state's attorneys defined the relevant market as major concert venues, specifically approximately 250 amphitheaters and arenas in the United States with capacities of 8,000 or more, hosting at least 10 concerts per year. By that definition, the state's analysts estimated Ticketmaster's share of primary ticketing at approximately 86%. Live Nation's defense argued the market should be defined more broadly to include all venues where concerts happen, including stadiums hosting sports, smaller clubs, theaters, and corporate event spaces. Under that broader definition, Live Nation's analysts estimated their share at approximately 44%. The jury sided with the state's narrower market definition, which is the standard antitrust approach when one company controls the most economically significant subset of a category. The 8,000-seat threshold captures the venues where most major tour revenue is generated. The legal conclusion the jury drew is that within the market that actually matters for concert ticketing, the venues where the artists everyone wants to see actually perform, Live Nation and Ticketmaster maintained an effective monopoly. The 86% figure is not a description of all ticketing everywhere. It is a description of the segment where consumer ticket purchases at the high-attention end of the market actually occur. An unusual feature of this case is that the United States Department of Justice, the federal antitrust enforcer that originally brought the lawsuit jointly with the states in May 2024, chose to settle with Live Nation mid-trial in March 2026. The settlement allowed Live Nation to retain Ticketmaster, required it to open its venues to rival ticketing services such as SeatGeek, required divestiture of certain amphitheaters, and capped Ticketmaster's ticket fees at 15%. 6 states joined the DOJ's settlement. 33 states and the District of Columbia rejected the settlement as inadequate and continued the litigation independently. Their judgment was that the DOJ's settlement preserved Live Nation's core structural power and provided behavioral remedies that the company could continue to work around. They opted to pursue a verdict at trial rather than accept the deal. On April 15, 2026, that judgment was vindicated. The jury verdict in favor of the continuing states gives those attorneys general substantial leverage in the upcoming remedies phase. The remedies under consideration include direct financial compensation to harmed consumers, divestiture of Live Nation's venue holdings, and a structural breakup separating Live Nation from Ticketmaster. The attorneys general are widely expected to press for structural breakup, the most aggressive available remedy. Live Nation will press for the milder behavioral remedies of the DOJ settlement as the benchmark. The remedies phase will run into 2027 and likely 2028. The case is far from final, but the legal architecture for transforming the live entertainment industry has now been built. The political conditions that produced the 2024 lawsuit existed because of a specific event in November 2022. When tickets for Taylor Swift's Eras Tour went on sale, Ticketmaster's verified fan presale system crashed under demand from approximately 14 million users attempting to access tickets simultaneously. Many fans who had received verified fan codes were unable to purchase tickets at all. Many tickets that did sell went to scalpers and resellers, who then listed them on secondary markets at multiples of face value, sometimes $10,000 or more for premium seats. The public reaction was disproportionate to a normal ticketing failure. Members of Congress demanded investigations. The Senate Judiciary Committee held hearings in January 2023 specifically about Ticketmaster's market power. The Federal Trade Commission opened parallel inquiries. State attorneys general from multiple states began coordinating. The political coalition that ultimately filed the 2024 antitrust lawsuit was, in significant part, assembled in response to the Eras Tour ticketing breakdown. The lawsuit did not allege that the November 2022 breakdown was itself illegal. System crashes happen. The lawsuit alleged that the structural conditions that made the breakdown possible, Ticketmaster's monopoly position, its inability to be displaced by competitors, its ability to operate without the discipline of a competitive market, were illegal. The error's tool breakdown was the visible failure that prompted the investigation. The structural exploitation it revealed was the actual case. The April 2026 verdict has been described in headlines as a turning point in live entertainment. Whether it actually reduces consumer ticket prices depends on what happens in the remedies phase, the appeal, and the regulatory follow-through. Three factors create substantial uncertainty about the consumer outcome. First, the remedies phase will not conclude until 2027 at earliest, and any structural remedy, divestiture, breakup, would itself take years to implement. The April 2026 verdict establishes liability. It does not directly compel any structural change to the market. Second, Live Nation has stated it will appeal. Appeals in major antitrust cases typically run 2 to 4 years. The DOJ-Microsoft case ran from 1998 to 2001. The Standard Oil breakup case ran from 1909 to 1911. The AT&T breakup ran from 1974 to 1982. Even if the states ultimately prevail on appeal, the practical timeline for consumer-facing impact stretches into the late 2020s. Third, the secondary ticket market, StubHub, SeatGeek's resale arm, Vivid Seats, and others, operates outside the scope of the antitrust verdict. The verdict addresses primary ticketing only. Even if Ticketmaster's primary fees are reduced, the secondary market that handles resale, with its own fee structures, remains effectively unconstrained. The structural fact is that the underlying scarcity, a finite number of premium seats at popular concerts, demanded by a far larger audience, produces the conditions where any ticketing arrangement will generate fees that consumers find painful. The monopoly amplified those fees beyond the competitive level by approximately $1.72 per ticket. Removing the monopoly returns the market to competitive levels. It does not return ticket prices to what fans wish they were. What we have walked through is the legal proof of a structural arrangement that fans have long suspected and the industry has long denied. In April 2026, a federal jury, after reviewing 5 weeks of evidence and 4 days of deliberation, found that Live Nation and Ticketmaster operated as an illegal monopoly. The jury found that the monopoly overcharged consumers by an average of $1.72 per ticket sold at major concert venues. The jury found that the unlawful conduct harmed competition in every state that brought the case. The Department of Justice settled mid-trial for a behavioral remedy package that the holdout states judged inadequate. 33 states and the District of Columbia continued the litigation and won. The remedies phase will determine whether the verdict produces structural breakup or behavioral modification. The appeal will determine whether the verdict survives the next several years of higher court review. The secondary market, the scarcity dynamics, and the underlying economics of live entertainment will continue to produce ticket prices that fans find painful. But on April 15, 2026, one thing became settled fact in American law. The ticket fees were not market prices. They were the price of a monopoly. The jury has now quantified that price at $1.72 per ticket. Whether the company that built the monopoly will be broken apart, divested, or merely behaviorally constrained, that decision is for the next phase of this case. The numerical truth of the overcharge is already in the record. Subscribe for more of the economics behind the systems and products that shape everyday life.